Hello, and welcome to Hospice Insights, the law and beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. What's new? CMS Provisional Period of Enhanced Oversight, application to new hospices. Adam, how are you doing? Welcome to the podcast.
Doing well, Brian. Thanks for having me on.
Great. I'm just getting used to being the host of the podcast, so
Doing
bear
great
with
so
me.
far.
Yeah, so far. I take all sorts of constructive criticism. I just ask that you be nice. You know, it's hard to follow in Meg's footsteps. I see I'm already missaying my word, but I'm glad I have folks like you to talk to who really are deep into the issues and know what you're talking about, so we can provide some helpful information to hospices out there. So thanks.
Yeah, happy to be here.
Great. So we're doing a series on enhanced enforcement efforts, and this is coinciding with the extension of the Provisional Period of Enhanced Oversight, known as PPEO, and Expanded Prepayment Review, which we call EPR. They've been expanded into Georgia and Ohio as of December 2025. So it's a new set of states and hospices and providers in those states who now have to deal with it. As a team, we've been working on these for a couple of years now in those western states, Arizona, California, Nevada, and Texas. So we bring a lot of experience to this, but it's going to certainly take on some new interest. And so we're doing a series on this. Today, we're going to be talking about what does it take to become subject to the PPEO, which by its terms applies to quote unquote new hospices. And there's a lot of ways to think about whether you're a new hospice or not. Adam, you on our team are kind of the transactional, the enrollment, the acquisitions, structural person who does a lot of that for hospices. So I think you are the person to help us unwind what this definition of new is, because it involves a lot of your background.
Yep, and it's a broader definition than you would think. So they have essentially four types of providers that are included under the definition of new. The first one is what you would expect, which is an actually new hospice, a provider who has just enrolled in Medicare for the first time. The second one, and this kind of gets into more of what I do, the transactional stuff, is providers undergoing a CHOW, which is shorthand for a change of ownership. The functional test that CMS applies in determining whether or not a CHOW has occurred is generally whether the EIN associated with the PTAN or the provider number has changed. Customarily, this would include an asset deal in the transactional context. So that's the second category.
So EIN, employment identity, you're going to have to get me up to speed on some of the acronyms here. Employer identification number?
Yeah, employer identification number. That's your federal tax ID. That's essentially the corporate version of a social security number. And so CMS has a crosswalk of those EINs, provider numbers, and national provider identifiers, the NPI. Those are kind of the three numbers that CMS looks at to identify a provider. And so a CHOW occurs when the federal tax ID, which is really the designator for that corporate entity, changes, which again would happen in like an asset sale.
So you have a hospice and you're acquiring another hospice, and that other hospice has its own PTAN. Is the PTAN then the asset that's being acquired?
Yes. In this case, yeah. And so you would be acquiring a whole range of assets, but the PTAN would be one of those assets that you're acquiring, in addition to like the license, the Medicaid agreement. No, for CMS purposes, yes, the acquiring entity would be purchasing that provider number, and so it would transfer from selling entity to the buying entity.
So do we know if when that happens, so you have an entity, the acquired entity now might have two PTANs, right? They had one to begin with, they acquired one.
Yep.
Which one of those, or is both of them now a new hospice?
That very well could be the case. And we've seen that before of providers who already have a P10 acquiring another one for whatever reason. It could be expanding into a different state or a different area within the same state. In that case, the way this definition is drafted, I would expect only the transferring P10 to be subject to PPEO, not any P10s associated with that EIN.
Yeah, and I think we have seen generally that these PPEOs are P10 specific. Although when we've worked on these, I think in California we've seen situations where they'll do a PPEO on a certain P10, but there are regulations that then allow them to extend the consequence of that PPEO to other P10s owned by the same entity. So even the association with a new P10 by an existing P10 causes some exposure. There's a separate regulation allowing them to extend that. So you want to be wary of that.
Yeah, it's definitely not without risk. And that's also kind of part of the broader guidance we've been giving clients and what we're seeing a lot of clients doing, which is sort of corporate restructurings that help isolate the liabilities of one P10 from the liabilities of another, or the assets of one P10 from the liabilities of another by splitting those P10s into different EINs, different entities. So whether that happens in the restructuring context or in the acquisition phase, where you maybe form a new entity to acquire assets, it certainly kind of serves that purpose.
Is that where a holding company might come into play? Where creating a holding company or making use of an existing holding company? How does that work?
Yep, that's exactly the way we're implementing this most of the time is having a holding company that's sort of like a parent company that would be the sole owner, for example, of multiple operating entities. Each operating entity would then have its own P10. So the liabilities from a corporate liability perspective, and generally how CMS enforces liabilities, those liabilities would not flow from one EIN, so from one corporation or LLC to another.
Okay, great. I think I took us on a bit of a digression there. There's these four ways to be a new provider. You talked about the brand new enrollee. You talked about the chow. There's two more to go. What do we have left?
The third sort of prong to this test is providers undergoing a 100% change in ownership information that's not a chow. And so what CMS is getting at here is a change of information, which is often triggered by an equity transfer. So transfer of ownership of a hospice where the EIN would be remaining the same, but the owners are changing. And in this case, the threshold is 100% of ownership. And so to contrast that with a chow, which is an asset deal, an equity deal, the same EIN would be associated with the P10 both pre and post closing, but you would have a new owner. So let's say you're trying to acquire a hospice, you have an existing company, the acquiring company would acquire 100% of the equity of the hospice and would become the sole owner. So whether that's shares or membership interests, if that transfer is 100% of the ownership, then you would be considered a new provider under this PPEO regulation.
Have we seen transfers of ownership of, let's say, 99.9% of the ownership or 51% or something less that allows for control, but that is something less than 100%? Is CMS, as far as we know, sticking with 100%, or is there risk involved in these less than 100% type of transactions?
I've not seen this applied to anything less than 100% transfer. Those transfers certainly take place, but in theory, you could conduct a 99% transfer of equity, and that wouldn't trigger this. The way the regulation is written, there are other thresholds and related kind of anti-fraud regulations. The 36-month rule comes to mind, which are triggered by a greater than 50% transfer in ownership interest. So we've seen CMS apply different thresholds in the regulations, but this one is 100%.
And the 36-month rule, that means you need to hold on to something. This is my non-transactional attorney interpretation. You need to hold on to something for 36 months before you're able to transfer it, intended to stop this churning and quick turnover of PTANs, essentially. Am I getting that right?
Yep, that's it. Either 36 months from your initial certification or the last transfer.
And I kind of threw out this hypothetical of a 99% transfer. So, you don't avoid the 36-month rule because that is a different threshold. Maybe you avoid a PPEO. Why wouldn't someone or two parties engage in this 99% transfer? What's the problem with those?
Yeah, if it's an arm's length deal, the issue could be you would just have an owner that still owns 1%. So an albeit small interest, but an interest in your company. And if you don't want to work with that seller, then that would be a reason not to do it. I mean, you could limit authority in governing documents to a large extent, but at the end of the day, there's still that seller that's entitled to 1% profits and has a 1% ownership stake in the company. So.
Yeah, and I guess why would the seller want to hang on to 1% and all the potential liabilities that might go on with that? So maybe it's good for the buyer, but why would a seller do that?
Yeah.
Unless they'll get extra money or something. So.
Right. Yeah, most sellers are one to get out these days, it seems like.
All right, and what's that fourth category of what makes a hospice a new hospice?
Yeah, the fourth category is providers reactivating their billing privileges. And so this would be in response to a deactivation, which is we talked about this on the podcast before, but it's a sort of remedy or enforcement tool CMS has that is short of actually terminating a provider from the Medicare program, and instead they deactivate your billing privileges. So you still have a PTAN, you're still enrolled in Medicare, but you can't bill. And so the remedy to that for a provider is to reactivate. And so that's the fourth prong, is if you've been deactivated and you are reactivating, even if you've been in the Medicare program for years and haven't undergone any transactions, that reactivation could trigger PPEO.
Are there any grounds for deactivation that might sneak up on people, or that might you be deactivated for what some could consider a relatively minor reason, but because of that, now you're on the PPO radar again? I mean, what are some deactivation circumstances that maybe don't seem as consequential in the big scheme of things?
Yeah, certainly. I mean, and as a matter of fact, we've seen an uptick in deactivations recently. It seems like CMS is kind of turning to this mechanism more than they have in the past. But one reason for deactivation that could come up often and that we've seen is not keeping your Medicare enrollment information up to date, and along those lines, not responding to the Medicare administrative contractor. If you are updating your provider enrollment information, not responding to the MAC and their development requests to provide any documentation or clarification that they may ask for in connection with those enrollment applications. And so it's common for providers to let their enrollment information lapse. Think about nonprofits who have boards that are turning over often. Board members have managing control over the entity, but are not really day-to-day operators in most cases. So it's kind of easy to let that information get out of date. And then when you go to update it or make other updates, if there's information that the MAC needs, if you don't respond to the MAC in the 30-day time frame that they give you, they can deactivate you for that, which is a pretty draconian remedy, especially if the provider is actually taking good faith efforts to provide that information. But we've seen situations where development requests don't get to the right people or are overlooked or lost, and then the time period lapses and the client gets deactivated. So definitely something to be aware of, in addition to just the already existing problems of deactivation.
Yeah, I guess so. You could be a hospice for 30 years, but then the right mix of circumstances occurs, and all of a sudden you're a new hospice as it relates to PPEO. and that's a place you don't want to be. So knowing about your transactions, knowing about for nonprofits, your enrollment information and keeping that updated. A lot to monitor to stay out of that new hospice category.
Yeah, and for three of those four categories, it's pretty easy to avoid, or you should know whether you're potentially going to trigger PPEO or not. You're either enrolling or doing a transaction. So if you want to avoid PPEO, you can just not do the transaction. The fourth prong, though, can happen in people who are going about their ordinary business, running a hospice, irrespective of transactional context.
Okay. So as far as these transactions, I understand there's lots of steps in the transaction process. There's the actual business side of it where you have purchase agreements or stock purchase agreements, asset purchase agreements. You need to submit updated 855s, the chow you were referring to, that gets approved. There could be a number of kind of identifiable steps along the way. Which one of those, or are there multiple ones, that is the significant one to deem you a new hospice? At which point in time or upon which event are you deemed a new hospice?
Yeah, so CMS is using the actual approval date of the application, which is a little bit strange because that's a date that the provider has no control over. It's within the MAC and CMS's discretion about whether that gets approved and how quickly they can process the application. And right now it's taking them a long time to process applications, but it is the approval date. So, in theory, if the Georgia and Ohio were just added to PPEO in December of 2025, if there was a transaction that occurred November of 2025 before this even was announced, but that application is still processing, it's possible that those providers could be subject to PPEO when that application is actually approved.
Yeah, and we saw, CMS puts out these bulletins, the MLN bulletin that they put out back when it was originally imposed on those four Western states. They revised it slightly to add Georgia and Ohio, but something that I thought was noteworthy was when they issued this updated MLN in December 2025, the date that they noted, that they identified as the significant one, kind of the, are you before or after this date in terms of triggering events? It was still July 2023.
Yeah.
And so there seems to be maybe a little uncertainty about, is December 2025 at all significant? Or is that just the next time they rolled it out to more states? And beyond that, it doesn't mean anything. Have we seen enough activity in this area to kind of discern, is December 2025 significant, or is it all July 2023? What's your observation on that?
Yeah, it's kind of early to see any trends around that and how they're enforcing it. It is sort of a strange issue. It's not clear whether that 2023 date was just an oversight in kind of the updated MLN notice, and that in fact they're going to be applying this December 2025 date. And that would be the most sensible application of the rule, but I would not hold them to being sensible based on some past experiences.
Yeah, and I think technically, this was applied effective, PPO became effective July 2023. So I think to be conservative, assuming that anything happens after that date could be a trigger until we get maybe some more clarity from CMS on that. That would be the conservative approach.
Yep, and they have regulatory authority to conduct PPEO, very broad authority, sort of outside of these notices that have been published that are not limited to these specific states or to a specific time frame. So I suppose they could rely on that authority regardless.
All right. Well, one thing about not-for-profits that I'm familiar with are member substitutions. That's kind of a way that not-for-profits might change who is in control of the organization. How does that fit into this whole PPEO new hospice structure?
This is sort of adjacent to, but just outside of the PPEO structure. The member substitutions are sort of the most common way that we see nonprofits doing transactions. And so a member substitution in the nonprofit space is closely analogous to an equity deal in the for-profit space. The key difference is nonprofits generally don't have owners the same way for-profits do. And so what a member substitution is doing is making another entity the member of the nonprofit entity, which is not an ownership interest. It's generally sort of a role that gives the member the ability to appoint board members and that kind of thing. So exercise control over the nonprofit, but not own it. And so in the context of member substitutions, there's no actual ownership change taking place. So it should fall outside of this PPEO, and it should be reported as such on the 855, meaning you would report the owner in Section 5 as having managing control, but not having an ownership interest. If you reported them as an ownership interest, that would not, or as having an ownership interest, that would not only be inaccurate, but it may also trigger PPEO just because of how they're reported.
Okay, well, that's a good heads up. Adam, any final words to those listening relating to this new hospice definition that everybody should be aware about?
Just to be cognizant of these definitions, what triggers them, and whether you're potentially going to fall within the definition new provider, particularly in the context of reactivations. Just yet another reason to avoid being deactivated. And then specifically in the transactional context, if you're doing a transaction that is going to be subject to PPEO, you can expect some cash flow disruptions because this is prepayment review. So we've seen buyers wanting sort of higher working capital targets at closing, potentially to absorb that cash flow disruption pre-closing. So there are certain sort of levers you can pull in the transactional context, subject to kind of the parties' negotiations that can lessen that blow. But yeah, something to be aware of.
Great. Well, this has been wonderful, Adam. Thanks so much. As I'm easing into the host chair, a guest like you makes it very easy. Guest, partner, colleague.
You're too kind. It's a pleasure being on.
You set a high standard for everybody else. So, but thank you so much. And to all the folks who are listening, thank you very much for listening. If this topic is of interest to you or you have any questions, feel free to reach out to me or Adam, anybody else on the Husch Blackwell Hospice, Home Care, Palliative Care team. We're happy to help, and we know what we're doing, so we'll be able to help you. Take care. That's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, take care.